Good afternoon. Ooh, y'all can do better than that, Texas, and other people joining us in the virtual space and in the face-to-face space. Good afternoon. I don't know. We might have to do one more run through, one more. The kids that I used to work with who were justice involved used to say, "Miss, don't do me." And I had to ask them, what does "don't do me" mean? And they said, "Don't do me" is slang for don't dismiss me, don't shade me. So I'm gonna ask it again, don't dismiss me. Good afternoon. I guess that's not an ask, but more of a call for call and response. All right, so I just want to say, many of you have approached me and said, "I thought we were going to hear you deliver a keynote during the lunch session." And I said, no, that is not what I was asked to do. I'm just the afternoon MC. So I bring you greetings. I am Courtney Harvey. I am the Associate Commissioner with the Office of Mental Health Coordination at the Texas Health and Human Services Commission. I also have the privilege of serving as Mental Health Statewide Coordinator and Chair of the Statewide Behavioral Health Coordinating Council and a Commissioner on the Judicial Commission on Mental Health. In our first afternoon session, we'll explore competency restoration practices and give you insights on the use of court-ordered medications, effective approaches for defendants deemed unrestorable, and streamlined methods to expedite competency restoration services in your county. Our moderators for this panel are Dr. Jennie Simpson, Associate Commissioner and State Forensic Director of the Office of Forensic Coordination at the Texas Health and Human Services Commission, and Matthew Lovitt, who is the Senior Policy Advisor for the Health and Human Services Commission's Office of Forensic Coordination. Our distinguished panel, we have Judge Nelda Cacciotti, the Acting Chief of the Mental Health Crossover Unit of the Tarrant County Criminal District Attorney's Office, Shana Donati Dallas, the Competency Restoration Program Manager at Star Care Specialty Health System in Lubbock. Woohoo, Star Care, that's one of our local mental health authorities. Shout out to you. Judge Elizabeth Byer Leonard, 238th District Court Judge in Midland, and Thomas J. Wooten, the Chief Public Defender for the Galveston County Misdemeanor Mental Health Public Defender's Office. Welcome you all.
Have to clap for us. Great. Thank you, Dr. Harvey, and good afternoon, everyone. So I am excited to share with you today the Texas Competency Restoration Guide. We will be talking about this guide today with our panelists, and we also have copies. Whenever at the end of the session, we do have copies over there in the back. So as we go through this, know that you will have a hard copy in your hands. So our topic is around best practices, and we know that best practices, the best way to develop them is based first on principles. So today we are going to be discussing the principles of competency restoration. We're going to share a structured decision-making tool with you that can be used for placement and competency restoration, whether it be outpatient competency restoration, jail-based competency restoration, or inpatient competency restoration services. So I'm going to be turning this over to Matthew Lovitt in just a minute to go over those principles, go over that structured decision-making tool, and then I will moderate our panel. But before I hand it over to Matthew, I really want to recognize his leadership in the development of this guide. Not only did he help steer the steering committee, he also lent his perspective as a person with lived experience, which is critical to this process as well. So with that, Matthew, I'm going to turn it over to you to walk us through the guide.
Thank you, Dr. Simpson, and good afternoon, everyone. Thank you. As Dr. Simpson mentioned, good afternoon. Thank you for the opportunity to share this, to be with you this afternoon, and also to share this really new resource that we developed for competency restoration stakeholders across our fair state. I'm going to be quick. The clicker, I believe this is there we go. How I intend to structure this conversation today is first by discussing the development of the Competency Restoration Guide, then highlighting two key elements, as Dr. Simpson mentioned, the competency restoration principles, as well as a competency restoration placement decision tree. After that, I'm going to turn it back over to Dr. Simpson so she can moderate the stakeholder panel that we have for you today. And fair warning, I'm going to be fairly brief in my review of these materials and the principles and the decision tree. We do have copies, as Dr. Simpson mentioned, over there for you on the left-hand side of the auditorium, or right-hand side, your right. And that middle black table, there's a stack of them for you today. With that in mind, I'm going to go ahead and jump right into the development of the guide. The guide was developed through a painstaking process that included the formation of a steering committee that included a variety of stakeholders in the competency restoration system, including judges, mental health clinicians, defense counsel, and prosecutors. We made sure to recruit panelists or steering committee members from our diverse communities across the state, so rural, urban, and suburban communities. What we then did was all participated in a day-long training facilitated by SAMHSA. It was a really engaging experience where we got to hear from leading competency restoration experts across the country, as well as from other competency restoration professionals in other states, North Carolina and Virginia, I believe. After that, we convened two focus groups to further refine and hone the content that we did develop through the steering committee's work. And then we ended with an additional review of some additional competency restoration stakeholders in other states as well as at the national level. A quite painstaking process, but it was really worthwhile, and I think it comes through in the competency restoration guide that we have for you today. Concerning the steering committee, as I mentioned, we did have stakeholders from across the competency restoration spectrum and across the state of Texas. So we had judges, defense counsel, prosecutors, and mental health clinicians. I mentioned that we did have members from suburban, urban, and rural communities across Texas. You will likely recognize several of the names on this screen, a few of whom are on the stage with me today, and a number of which are also in the audience with us today. And as Dr. Simpson mentioned, we couldn't have produced this guide without their expertise and their wisdom and taking time out of their busy schedules to help us produce this document. And we really appreciate everything that you guys did for us, sincerely. That said, let's dive right into the principles of competency restoration. And again, these were developed through a peer review process that included a lot of stakeholder input. This is not something that we just developed unilaterally. So for your reference, the first principle included in the Competency Restoration Guide states that access to robust, appropriate, and timely community-based services and support is essential, not only to reduce the number of people who are entering the competency restoration system, but also to help the people who are exiting the competency restoration system successfully reintegrate back into the community. Next, people for whom the compelling interest to prosecute is low are not considered for competency restoration. Conversely, people for whom the compelling interest to prosecute is high are considered for the competency restoration system. And I think it'd be worthwhile to take a second to underline that phrase, compelling interest to prosecute. What does that mean? Well, it'll likely differ from community to community based on the local services and supports that are available to you locally, and also how you guys practice the criminal justice system and how services are provided in the local community. A few factors to take into consideration when trying to develop an understanding of compelling interest to prosecute may include nature of the charged offense and any aggravating factors, circumstances under which the offense was committed, concerns and safety of alleged victims and the community, availability of inpatient, outpatient, or jail-based competency restoration services, as well as the wait time to receive those services. It's worth noting that these principles, I should have mentioned this at the top, but a slight oversight. These principles are meant to be suggestive rather than prescriptive and applied in the context of the services and support that are provided in your local community. So how they're applied in Byer County is likely going to be different. How they're applied in Cherokee County is likely going to be different than how they're applied in El Paso County. So just for your awareness. There we go. The third principle, to paraphrase, competency restoration services are not what we consider normal mental health treatment or traditional mental health treatment. Although competency restoration often does include services that are included in the traditional mental health treatment, the primary purpose of competency restoration is to stabilize symptoms of mental illness and to provide legal education so that person can resume the legal process. Fourth, we are responsible and accountable for systematic efficiency and equity in competency restoration. The Code of Criminal Procedure clearly articulates the qualification criteria for competency evaluators, and there's a wealth of research out there on best and promising practices for mental health clinicians to apply when providing competency restoration services. Of course, the competency restoration system would be well served if we were able to adhere to those guidelines and suggestions to the best of our ability. There we go. The fifth principle of competency restoration emphasizes the importance of early identification and intervention, not only in providing access to competency restoration services in a timely manner, but also helping to prevent justice involvement and the potential need for competency restoration services in the first place. 6, the competency restoration system is defined by strong collaboration between all the relevant parties. Competency restoration touches multiple systems, and any effort to improve efficiency and efficacy in the competency restoration system naturally should include all those different systems or stakeholders from those systems. I believe the 7th principle is fairly cut and dry. Competency restoration stakeholders should promote statutorily required timelines for tasks that fall within their respective domains. Again, the Code of Criminal Procedure does a pretty good job of laying out the statutorily required timelines for the various elements in the competency restoration process. Principle 8 relates to data-driven decision-making. The analysis of relevant data points may help stakeholders identify bottlenecks in the competency restoration process and opportunities to improve efficiency and efficacy in the system. In the Office of Forensic Coordination, one data point or 2 data points that we actually like to look at are the time between arrest and a commitment order and the time between commitment order and admission. And if we notice over a period of time, those periods of time are increasing or decreasing, we have an opportunity to identify why that is and maybe identify some opportunities to improve efficiency in the system. Principle 9 suggests that it is prudent for competency restoration stakeholders to have a firm understanding of the competency restoration process from beginning to end, including the roles of other stakeholders. For example, a mental health clinician would be well served to understand the role of the judge in the competency restoration process as it relates to the adjudication of a person found incompetent to stand trial. Lastly, although we certainly should use our professional judgment when making decisions around competency restoration placement, those judgments should be informed by research, data, statute, administrative rule, and the best available resources at our disposal, which, not coincidentally, brings me to the next element of the competency restoration guide that I want to present to you today, the competency restoration placement decision tree. The placement decision tree was developed to help judges, lawyers, mental health clinicians, and community members for that matter, identify and prioritize the various factors that can be used to determine the best available competency restoration placement for people found IST. Similar to the principles we just covered, this decision tree is meant to be used in the context of the local services and supports that are available in your community, as well as the prevailing sentiment around competency restoration, how to deliver those kinds of services. Although the decision tree may seem fairly straightforward, we wanted to highlight a couple elements for you today just to give you a better picture of how this would actually work in any particular community. First, the competency restoration tree does provide a set of exclusionary factors on the top row there for you to take into consideration when making a decision around the appropriateness of competency restoration placement, including compelling interest to prosecute, the presence of an intellectual or developmental disability, a neurocognitive disorder, or a traumatic brain injury, a substance use diagnosis paired with a substance use related offense, and previous unsuccessful attempts at competency restoration or a low likelihood of restoration. all those exclusionary criteria should be taken into consideration upon suggestion of incompetency. After we take into consideration those exclusionary factors, we can move down to the second tier of the placement decision tree and start thinking about those various different elements that might help us make a better decision around the appropriate placement for somebody who's been found incompetent to stand trial. The first one, of course, would be violence or criminogenic risk. And ideally, this would be determined using a validated risk assessment tool where we can understand anybody's propensity to commit any kind of criminogenic act in the future or any kind of violent act in the future. And you can see if the person assesses low on the violence or criminogenic risk, they would move to the left side of the decision tree. If they rate moderate to high, they would move to the right side of the decision tree. After those, the second element to consider after violence or criminogenic risk is clinical acuity. How severe is this person's mental health condition or their associated need with their mental health condition? Again, if it's low, left side of that particular side, or moderate to high, you move to the right and then down. The last element we want to take into consideration when trying to determine the most appropriate placement for somebody who's been found incompetent to stand trial is, of course, legal severity and potential community impact of releasing that person back into the community. So if if there is a lot of concern from the community members or from a family member who's perhaps maybe the victim or the alleged victim of the offense, it might not be appropriate to release that person into the community, or the risk to the community might be assessed as high. And of course, you move that appropriately and help us find the appropriate competency restoration placement. I was going to walk us through a brief example, but we are running a little bit short on time, and I wanted to make sure our panelists have ample time. As I said at the beginning, this is a really brief introduction to the tools that are available in the Competency Restoration Guide. We do have copies over there. There are also digital copies available on the Texas Behavioral Health and Justice Technical Assistance Center website. If you need that URL, come find me after this presentation. I'd be happy to give it to you. With that, nothing more. I'll give it back to Dr. Simpson.
Okay, thank you so much, Matthew. So I'm going to give some questions that should promote good discussion around these principles. I want to try to leave some time if we do have some questions. We'll see if we get there. But then our panelists, if they are available and are not in another breakout session, will also be joining myself, Chris Lopez, and Elise Ferguson in the breakout session on competency restoration. And I'd encourage any of our steering committee members, if you would also like to be at the competency restoration breakout session, please come there. I think this is an opportunity for all of us to come together and ask questions and answer them together as well. So I want to start with Ms. Dallas. As a mental health clinician, can you talk about what your role is in the competency restoration process? We know that one of the principles is understanding everyone's role in the competency restoration process.
Sure. Excuse me. So I am a competency restoration program manager for Star Care, the local mental health authority over in Lovitt, and I am over the jail-based competency restoration program and the outpatient competency restoration program. I have worked with competency restoration since about 2014. I started with OCR and helped put together our jail-based program whenever we started that back in 2018. And in that role, I do everything from working with and coordinating with the courts, the competency docket that we have there in Lovitt County. Also, I work clinically as an educator and provide clinical support on the ground to our program staff. And I work with the defense bar, the Lubbock Private Defender's Office out there, to coordinate care for our individuals who are ordered to competency restoration services. And I also work with the Lovitt County Sheriff's Office, since that is where our jail-based program is housed, is officed. And we have good relationships with a lot of our stakeholders, and it's taken a lot of time. It's taken a lot of time and effort on everyone's part to encourage that and foster that for the success of all the programs.
Can I ask in terms of best practices, is there something working with your sheriff's office that you would recommend as a best practice when implementing JBCR?
Sure. When working with your sheriff's office to implement a jail-based competency restoration program, I think it's really important to have a willingness to hear out each other's side, each other's perspectives. I'm not law enforcement. I'm an LPC. I'm a clinician. And I can respect law enforcement's perspective. I can respect the jailing system's perspective, criminal justice system. And I hope that in the relationships that I've built, that they are able to hear out and respect my views when I'm trying to make a recommendation on somebody's appropriate housing and which pod they may need to go to, or when I'm trying to make a recommendation for a behavior management plan and things like that. So I think the best practice, I would say, is to have a willingness to hear each other out, learn about each other's perspective, and a willingness to be influenced.
Thank you. Okay, I know this is one that many of you are interested in hearing about, and Judge Cacciotti, I'm going to ask you this. So Talk to us about the factors that you take into consideration when you're thinking about placement. That can include just community impact, some of those compelling interests to prosecute. I think that's, one of the principles that, a little bit more discussion on that would be great.
Sure. So first off, I want to say that consideration should always be given to the least restrictive, appropriate setting that's available in one's community. So placement options can be outpatient competency restoration, jail-based competency restoration, or inpatient restoration in a state facility setting. So also, though, keep in mind that someone doesn't always have to be ordered into competency restoration. So a person can be diverted from restoration placement altogether at any point in this process. So when I'm reviewing someone for determination of what the state's position is going to be on competency restoration placement, I'm going to look at about 4 to 5 factors. And actually, even prior to returning to the DA's office earlier this year, I was the mental health magistrate for Tarrant County, and I would review much of the same factors that we're going to talk about when deciding which restoration program to order someone into. So the first thing I'm going to do is look at the offense. What is the person charged with? What are the facts and circumstances of that case? Are there community safety or victim safety concerns? Does the state have a compelling interest in prosecuting that case? To me, there's a big difference between someone who's charged with murder or sexual assault versus a low-level misdemeanor offense like criminal trespass or Class B theft, or even a low-level felony drug charge. I'm also interested in what did the expert say? In that competency evaluation, what was the expert's opinion with respect to diagnosis, the ability for the defendant to restore, and the length of time they were going to take to restore? Is this someone who's been through restoration several times in the past? And was it successful? Are we looking at someone who's, consistently contacting our jail system and being evaluated and going through restoration programs? Is there an indication that they're restorable? Have they been restored in the past? Another thing I will try to get information on is behaviors. Is the defendant exhibiting behaviors that would indicate they pose a danger? Are they in an acute psychotic state? Or are they stable? Are they willing to engage in treatment? Are they medication compliant? And going back to what the expert said, what did the expert recommend with respect to treatment? And is that treatment and are those services that meet the needs of the defendant available in our community? And then the last thing I would look into is bond status. If a person has already been released on bond and they're doing fine in the community, in other words, they're meeting their bond conditions or showing up for court, they should absolutely always be considered for outpatient competency restoration first, if that can safely and effectively be delivered in the community, if it's appropriate and if it's available. And there may even be candidates or defendants who are good candidates for outpatient restoration in the jail, but maybe they just can't make the bond that was originally set by the judge. So in those cases, I would, consider agreeing to a personal bond if they're eligible, or a reduced bond so that they could be released and do an outpatient program. So if in reviewing all of these factors, there's not really a community safety concern, state doesn't really have a compelling interest to prosecute, and especially if there's also an indication that someone is not restorable, that's someone I'm going to look at as a candidate for diverting from the criminal justice system, but also competency restoration altogether. If, however, we have a compelling interest to prosecute the case and we need to pursue restoration, then these are some of the factors that can be used or some of the examples of factors that can be used to determine what is the least restrictive competency restoration program available and appropriate for a particular defendant.
Great, thank you. And Chief Wooten, coming to you. So I know, some places may not have an outpatient program. They may not have a jail-based program. So can you talk about what some of those alternate dispositions may be, or strategies that may be utilized by defense, by the courts, by prosecutors?
Yes, ma'am. Well, you know, you got to move those cases. It's worst case scenario for your person sitting there on a criminal trespass, aging out or timing out, waiting on competency restoration. That's not going to happen because it's a Class B. What we do is well, I was going to say aggressively, but it's collaborative now, right? So we persistently pursue competency, we pursue dismissals, and we pursue civil commitment. Everything I'm going to talk about today really has to do with misdemeanors for me because that's what I do now. In a former life, when I was down here on a capital case, I never sat across from the state and asked them to dismiss a capital based on competency. But what I will tell you is that's what we do on misdemeanors. Never miss a chance to have your person evaluated to see if they meet criteria for civil commitment. Because if they do, then you can get them to a hospital and possibly get them some medicine, and God knows how long they'll stay there, but at least they'll be there for a while, and that's best case scenario. But remember, you have to have the district attorney's office on board to dismiss those cases and transfer it to probate. And let me stop for a second and talk about the district attorney's office. You know, you've got to get them on board. It's got to be a collaborative situation. If you haven't sat down and had lunch with them or coffee or whatever and talked to them about this, you need to. Now, is that what I did here? Oh, no. I was lucky enough to walk into a county where the elected DA, Jack Rohde, had already demonstrated a strong commitment to help people with mental illness. But you've got to get them on board. And so if civil commitment's not an option, then make sure you file the suggestion as soon as possible so that if your person's in jail, they're in jail as little as possible before the report comes back. And once you get that report, you know, in the old days, we'd move to have them declared, and then the other side would ask for that. No, we just take that report and we just start waving it around. And we go over to the state and we say, hey, this person's incompetent. We don't really care if it says they're going to be restored or not because it's just a Class B misdemeanor, say a criminal trespass. And we use, fairness arguments. We say, basically, look, this county doesn't have OCR. If they were in Harris County, they'd have that, but it's not fair that they don't have that here. We do have jail-based. We have an excellent program that just started, but they don't keep a couple of beds for me, for my serial trespassers, right? So we say, look, this person's already been in jail long enough where they would have never gotten this much time if they had pled. So let's go ahead and just dismiss this case. And we've been successful with that. And let's say you have a situation where that person, well, I won't say if, when that person comes back, you already have a competency report with their name on it. So here, old Teddy's back at Walmart because he thinks he owns Walmart, and the report addresses that. And so when he comes back, you don't have to sit around and wait for that. You can go over to the state and say, look, this Teddy's back and here's his competency report. What are we going to do with that? Let's dismiss it. He's already been in jail for 5 days or 6 days. Now, obviously, this works way better with nonviolent cases, but even if you have an assault causing bodily injury, our clients like to assault their family members. So maybe the family's on board for this dismissal. So the compulsion to prosecute goes down. But the bottom line is, and you could sit down with that decision-making tree, maybe get the judge involved, but whatever it takes, you've got to move that case. And lastly, what I'd say is if you find a situation where the state can't or won't move that case, and you have somebody who's going to sit there and time out. Time out being the statute says that someone can't be incarcerated waiting on competency restoration for longer than they would longer than the maximum for that jail sentence had they received the maximum. I was about to say longer than they would be in jail, but see, that's a distinction. And that's a distinction that we make because if a person who is competent gets the maximum from a judge, they may get 180 days, but in this county and most counties, they're only going to do 90 days, whereas the statute says they time out after 180. We've also been successful by making that due process argument, saying, look, our guy should get time, basically good time, because clearly the statute meant for it to be equal and you to not have a penalty because you're incompetent. And at least the DA's office here has bought that argument because, they're great. If not, file a motion, see what happens. Remember, your client doesn't have to be competent to get a dismissal.
Great, thank you. And Judge Leonard, one of the key principles is also around collaboration. So we had a great conversation, and one of the things you mentioned is taking someone to lunch. So let me ask you, who do you take to lunch? Who do you need to take to lunch? What does that look like?
Well, so many of us in this room are not mental health providers. And we got to remember, we need to stay in our lane. I don't need to start pretending like I know anything about medicine or being a therapist or doing any kind of restoration. You got to make sure you get the appropriate people delivering the appropriate services. And sometimes that's a hard lesson if who you think needs to be playing doesn't want to play. And so the first, you have to go get your LMHA. I've got Chris Barnhill here. You guys have been great. You are my third CEO. And they have been wonderful. They've always said yes. And they have really made mental health court and jail-based restoration a priority. So without them on board, take them to dinner because they are really, really an important player because they are going to be the ones delivering the services in the jail. They're going to be the ones who employ the qualified mental health professional, most likely, unless it's the jail. If they aren't on board, then it's going to be an issue. It's also an issue with medication. They can also provide some kind of medications if they have grant money, because sometimes the counties don't want to pay for meds, and but they can, and so it can kind of get territorial. So you need to be careful there. I believe the statute also says that the jail has to provide space for competency restorations. You just can't do it in the hall outside a jail cell. So you need to have the jail on board that they think that this is important. That's usually pretty easy because once they see how medication can help those suffering from a mental illness that's in their jail and how much better the work environment is for their employees, I never had a problem getting the jail on board. But they have to be willing to provide the space, provide the security, the transportation, and medical also. The nurse, whoever they contract with, whether it be county employee or a third party, they have to be on board also to make sure they see the patients and they can get them in front of some kind of provider or prescriber who can get the correct medications so they can get stabilized. And then once they get stabilized, it's the legal education part of it, your qualified mental health provider, professional, whoever that person is, can do that. But it's really your LMHA that you've got to get on board. It's an easy sell to the commissioners because it saves so much money. I talk to people and they say, well, our commissioners aren't going to pay for a QMHP to be there or somebody. And it's like, well, just ask them how much it costs per day to house somebody suffering from a mental illness in your jail. One day. Multiply that by about 400, the wait time for a state hospital if it's the maximum security unit, and then think, okay, if we didn't multiply by 400, but we multiply by 60, this is your savings. You can pay for a lot of stuff. We're in the millions now of dollars saved, just in Midland County. We're small.
Great, thank you. And before we end, I'm just going to go down the line here and ask you, based on your experience, where you sit, what is one suggestion you would give to colleagues in other communities who want to improve their local competency restoration process?
Well, it sort of goes along with what Judge Leonard just said about, take them to lunch. You need opportunities to have face-to-face discussions. I mentioned how we have a competency docket where we meet to check status for compliance and where people are at with evaluations and things like that. And that's helpful on the one hand for getting people through the process. But I think it's also helpful, this last year we started having quarterly meetings. The judge is there, then also the private defender's office, the prosecutors, the assistant district attorneys are there, along with all of us through Star Care and the jail services side of Star Care. And we are able to talk out any kind of concerns or problems that we see. And it's been very helpful, I think, to encourage the communication.
Going along with that, it really does take collaboration and wanting to be a part of the solution. And so what I am a big proponent of is creating those local restoration programs in your communities if you don't have one, whether it's outpatient restoration or jail-based restoration, because that can have a huge impact in your community on reducing jail days and on reducing fiscal impact on the local and state systems. If you can have successful local restoration programs, you will see the advantage and the benefit on the whole restoration system as a whole for your community.
Thank you. Chief?
I guess what I would say is, and I really have no business giving any suggestions to anybody in here except maybe the attorneys. What I would say is, if you're on my side now, and I've been on both sides, go sit down with the state and say, listen, I've got this guy, and you know, he's somewhere along the line he became bipolar, and he has trouble taking his medicine, and he's been living on the street. And here's a picture of him, and he for some reason goes to this one place. You know, we have a guy that in real life goes to the Port Authority. We don't know if he's trying to travel somewhere, but that's where he goes. And instead of walking in and say, okay, I filed a suggestion, so, you know, here's what's going on with this case. No, sit down and say, listen, you know, I'm telling you about this guy because he needs your help. What are we going to do with him? What are we going to do with him? Not, and by the way, I don't mean to be cheesy. You don't say that on a motion to suppress. You basically say, I filed the motion to suppress. I think this is BS. And they're like, no, it's not BS. Did you say, you know, okay. That's fine. But when it's somebody involving mental illness, I find that whatever the tide, whatever has turned, and people across the board, DA's office and criminal defense people, and society as a whole, they really do care, and they understand that people didn't choose this. You know, the guy with the 8-ball, he probably chose to have that 8-ball, you know, on him when he got picked up. But these people didn't choose that. So sit down with the state and say, you know, what are we going to do with this guy? Give me some help.
Great, thank you. Judge Leonard?
To the judges out there, I would just say do something. Start somewhere. It doesn't have to be a full-blown program if you don't have everyone involved, but you can always set bond conditions. You can have status hearings. You can connect people with services if it's outpatient. You can do follow-up until you kind of, I mean, if you're having a problem, getting everyone on board and doing a full-blown jail-based or outpatient. But I just say, you know, start somewhere and start building some data so you can sell it to whoever is not on board if that's your problem, getting people on board. If that's not your problem, I would say there's nothing, I think, more effective than this jail-based restoration. It's really not a difficult program, and it really, I think, I'm not going to say it's life-changing, but it sure does impact the lives of people who are sitting in jail that are not competent to stand trial, that are sitting there for, you know, months, literally. If you can get them competent, get them on bond maybe, or just get their case tried. So I would just say start somewhere and just commit to doing something.
Great, thank you. We have time for one more question. I'm going to ask each of you, and Judge Cacciotti, I'm going to start with you. From the principles, if you had to select one, what would be the one principles that you think could have the greatest impact?
I would say start looking at diverting individuals from competency restoration in the criminal justice system as early on as possible if they are determined not restorable. As early as you can, when there's an indication or suggestion of incompetence and an indication that a person's not restorable, start looking at figuring out what is an alternative solution that would be appropriate for this person. This is at least in my community, been one of the hardest populations for us to deal with because it always seems that they are charged with the assaultive offenses or the really aggravated cases. And so finding placement for them, such as in a nursing home or if they're suffering from dementia in a memory care facility, can be very difficult if they have an aggressive nature out of that condition. So starting early on, and again, thinking outside of the box, connecting with anyone that you know that can possibly help you do that as early as possible can really help get the person where they need to be and get their needs met, but also, save them from spending a lot of time in jail in that sort of condition and deteriorating and languishing. So that would be my one thing to do.
I think the primary concept for me that I appreciate that we've put into this tool guide or guide on competency is competency restoration should not be considered mental health treatment. And I know there are a lot of times in these situations where we feel pretty helpless and want to provide support and maybe even a safety net of sorts for the defendants involved in these situations, but there are better ways to get them into mental health treatment and help them stabilize in the community, and competency restoration sometimes isn't the best answer for that. And so I think that's where, like some of the others have just said, that it's really important to kind of look at if this makes sense for some of those maybe repeat criminal trespass situations. And I just give that as an example, and to realize that there are other resources that your local mental health authority can help you with in getting that person into services and hopefully helping them remain stable.
Thank you. Judge Leonard?
Okay. I would say collaboration and continuum. You have to remember, once somebody is found to be competent to stand trial, it doesn't end there. That just means they can start in the criminal justice process. So you have to make sure that somebody's continuing to take care of them, that their medication is still correct, that they're continuing to take that medication. So you have to have that collaboration with whoever is providing that care. And if they're getting out of jail, make sure they're getting out of jail with some medication and they know where the local mental health authority is so they can get an appointment to get in services on an outpatient basis. So remember, you can restore somebody to competency all day long, but that's just the beginning of the criminal justice, the court part of it. So you need to make sure you just don't stop there at competency restoration.
Well, I would say number 2, where it talks about the compelling interest to prosecute based on, for me, a better way to say this is let's restore the people who really do need to go to trial. The serious cases. I've represented those people, I've prosecuted those people, and the bottom line is those trials need to continue. The point is, when you're advocating for your person, like I was talking about, make sure that it doesn't seem like you're trying to say that if someone is incompetent, they're not responsible for their actions no matter what it was. And that this is just another way to go through and try to get dismissals on every case that exists. because then you lose credibility, and you probably don't really even think that. So make sure that you don't project that. Make sure you understand that if you were talking about a murder, it'd be a whole different situation. But if you're talking about the 350th time they've gone to Walmart, then let's maybe just get rid of that and see if we can do something else to maybe help them understand that they don't really own Walmart.
Great. Thank you to our panelists very much. And before we end, I'm going to say, because collaboration, we've just heard that so much. First of all, I would love to ask the HHSC folks who are here to stand up, because we want to collaborate with you too. And so please stand up, show that you are here. If you need to talk to anyone, come find one of us. We have Chief of Forensic Medicine, our Texas State Hospital System, our legal services. These folks are here to collaborate with you. And then second, I'd like the steering committee members to stand up too and be recognized for the amazing work they did on this guide as well. So please, with that, give them a hand, to give our panelists a hand. Thank you so much.